Hello, my name is Dorota Boissel. I'm a general counsel at Main Partner. In today's presentation, I would like to introduce you to the concept of a trust. First of all, I would like to start by mentioning that a trust is not a modern idea. It already existed in ancient Rome and Greece and was further developed in 12th century England. Crusaders who were leaving the country for a long way to Jerusalem would often decide to transfer the ownership of their lands to someone they trusted under the arrangement that the ownership of these assets would be transferred back to them upon their return. Thanks to this arrangement, the land was continuously managed, the taxes were paid, and the family of a crusader was provided for. Unfortunately, once crusaders were back to England, new owners would often refuse to transfer the property back, as it was initially agreed. As a result, crusaders would petition to the king, on whose behalf Lord Chancellor would normally determine that it was equitable and fair that the land is returned to the original owner. However, the application of the trust did not stop with the times of the Crusades. Nowadays, a trust can be described as a legal arrangement whereby the owner of certain assets like real estate, portfolio of securities, collection of cars, or simply cash, so-called settlor, transfers such assets to another person, legal or natural, called trustee, to keep these assets and to manage these assets for the benefit of another group of persons called beneficiaries. You can say the same depicted on our slide here. The settlor transfers the assets to the trust fund. From this moment, these assets belong to the trustee, and then trustee from time to time can make distributions of the assets to the beneficiaries. I would like to underline that this is just a very basic structure of the trust. And depending on the situation, you can have also different actors involved, such as, for example, protectors who are independent third persons or entities who monitor and ensure that the trustee is acting in accordance with the trust deed and also is acting in the best interests of the beneficiaries. You can also have advisory bodies and committees who are consisting of trusted friends, relatives, beneficiaries, and qualified advisors who can advise the trustee on issues such as management and investment, distribution of the trust assets. Such committees may also advise the trustee on regular basis on various matters which the trustee might not be in a position to know. For example, current family status or the needs of the beneficiaries. The establishment of a trust in Cyprus is fairly quick and easy procedure. It essentially requires drafting of the trust deed and later the transfer of the assets to the trustee. The trust deed is an essential document for the creation of the trust. It governs the trustee's rights and obligations. It also includes the initial list of beneficiaries or their classes. In addition to that, the settlor may choose to sign letter of wishes. It is not a legally binding document, but it can provide useful guidance to the trustee on how to manage the trust. What is also important, the settlor may change the letter of wishes at any time. To sign the trust deed, you do not need to be present in front of any notary public, in front of a court or any other administrative body. There is no incorporation or long registration procedure. Once the trust deed is signed, it shall be stamped with the stamp duty commissioner in Cyprus in order to be used as an evidence in court in case such a situation arises. The stamping is also rather simple, can be done within certain hours, and because it takes place after the creation of a trust, it does not delay the process. Later, the particulars of the trust are also recorded with certain administrative bodies. Nowadays, thanks to its unique features, the trust can be used for the two main goals. First of all, this is asset protection, which means the protection and preservation of the assets from potential creditors and other claimants. You can also use a trust for inheritance or so-called succession planning, which would be the protection and preservation of family assets for future generations to come. In the next presentations, I would like to discuss with these topics in more detail, therefore stay tuned.